Good afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. My name is Jenna, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, the cutting edge. Those of you joining us live this afternoon have the opportunity to ask questions of our speakers and interact with the crew. So if you have any questions, please type them into the comments section below, and we will be sure to address them. Episodes are released each week following the live broadcast. So if you have anybody you want to share the episode with, they can either view it on YouTube or download it in numerous different formats, I think on Spotify, Apple, iTunes, or whatever, all these different places. So please feel free to spread the news. Also, make sure that you click the subscribe button and the alerts icon so you don't miss an episode. Today, we have Andrew Garza and Alexa Mahony with us to talk about their $100 million trial verdict obtained using edge techniques. And we've been trying to get Andrew and Alexa on the podcast for a while now, so I am thrilled to have them with us here today to discuss this incredible trial result. As always, we will put their contact information in the description below. So if you have any questions about this topic, this trial, or anything edge, you may feel free to reach out and discuss with them directly. Andrew and Alexa, tell us a little bit about the facts of your case and then dive right in and tell us how you used edge techniques to obtain this incredible result.
Oh, well, thanks for having us. First of all, Jenna, I appreciate you taking the time to be here with us today.
Absolutely. Yeah. I'm so excited.
Yeah, thank you very much, Jenna.
Mm-hmm. And for those of you that don't know, apparently New England law has got a connection because Jenna and I both went to school together and graduated, and it kind of feels like there's something in the water in Boston. So
there is. Tiny fourth tier little school, scrappiest people I've ever met. I mean, honestly, every time I meet a Nestle alum, they're doing really, really great things. So
I think we should start passing out slingshots for the Goliath slang. So thanks so much for having us. We're thrilled to be here. Alexa and I tried the case together with an attorney from our office, Andrew Ranks, and my partner, Ryan McKean. And it was a labor of love over the course of about 5 years. And it's a story that begins in September of 2017. Our client was 42 years old at the time. He was born in Puerto Rico. He and his wife both moved to the United States and to Connecticut when they were very young. Grew up here, made a life here, went to high school here, were married, had kids here. And he's just salt of the earth, hardworking guy. We got along very quickly from the beginning because my partner and I are both from blue collar backgrounds. They bartended and waited tables for forever. And our client, Mikey, is a service industry guy through and through. I mean, also, so we had that sort of common experience. And, he's probably about the hardest working person I've ever met. And he worked his way up all the way after graduation until he was working at a lighting distributor in Connecticut. And he had been there, and that was his home away from home, and might have been his home depending on who you ask. He loved the job and loved working there and the people he worked with. And, he was there for years. And then unfortunately on a weekday in September of 2017, he walked in for the last time because he walked in and he was picking an order for a client, and unbeknownst to him, a temp worker in an aisle next to him was trying to take an object down from an upper shelf, knocked it down, and it paralyzed him. And so OSHA was on scene pretty quickly, emergency personnel, police, fire. It was very dramatic. And, he was transported and had a surgery and was told, look, you have basically a 1%, 3% chance of ever walking again. And, from the very beginning, this case for us was a little bit like a movie, not because of anything we did, but because the things that continued to happen in the case were things that you couldn't write if you wanted. Like Hartford Hospital is a giant hospital in Connecticut, hundreds of rooms, and his family was told in the same room where they were told his mom was going to pass away, like almost to the day, 15 months before that, what his prognosis was going to be. I mean, just sort of the confluence of things that happened in this case over time were a little bit hard to believe. And so we were retained pretty early, which was great because we were able to jump in and send letters out immediately, looking to preserve the product if it still existed, the surveillance video, if any was there. And then our process started immediately looking at, how did this happen? Was it preventable? What was the root cause of this? And the very obvious and short-term answer was the guy in the aisle next to him on the reach truck in the company that sent him. But, the more we dug into it, the more we realized that there was more to the story. And ultimately, we ended up, our client was a huge asset too, because he knew lighting inside and out. I mean, even to this day, he could tell you the barcode of the object that he was picking in that aisle when he was hit. I mean, I think the event has a way of imprinting, but he's got a good memory. And he said, something wasn't quite right about how that product was coming in. He thinks it should have been secured to the pallet. And we started to dig into this idea that maybe there was a securement problem with what fell on him, and worked our way all the way backward, all the way until to China. I mean, we figured out that the product was manufactured in the Zhejiang province of China by a subsidiary of Philips Lighting North America, just, that mom and pop operation that they are.
Yeah.
And
little teeny tiny company, right?
Yeah. And they had outsourced a lot of the work, and the product was shipped to the US. It was arrived and at a port. It made its way to Pennsylvania. It was unloaded there at their warehouse. And our position became, based on our investigation, that they didn't do the safe thing. They had an opportunity, the means to do the right thing, to secure it to the shipping pallet when it went out to their customer, our client's employer, and they didn't do that. And more importantly, had they done that, we wouldn't be here. And, we ran, I think something like Alexa could tell you, maybe over 10, it felt like 10 focus groups over the course of the case. Some over and over again, like Groundhog Day, to unpack and see what people thought. And, we realized pretty quickly, like all things, I think you have to show mechanism of injury. I mean, this was an unwitnessed incident. We had surveillance that showed like the side of the aisle, but not what happened. And we were realizing, look, even, as I explained it earlier, my client's in one aisle, basically aisle 6 of a supermarket, and the Temps in aisle 7. We had focus group folks like 2 hours into a group saying, well, so was he next to the guy on the reach truck? And so maybe there was some comparative negligence. So
yeah, they just weren't getting it, like based on a verbal description alone. So we're like, what visuals can we give these people to help them understand what's going on here?
Yeah, no, I have to admit that I'm like, okay, wait a minute, where were they? What was he doing? So,
exactly. Right. And so we came prepared. So we realized, it's critical to show a mechanism of injury, a mechanism of event. And we immediately got to work developing some animations with a great group of folks out of Boston, Total Trial Solutions. I can't say enough good things about them. What they were able to do, I mean, essentially, it's really impressive. You can, these days you can do a site inspection of the warehouse. You can use radar to map every specific point to create basically stick figures or a stick outline of an environment. And then they can take measurements and photographs and layer those on top of the points, the point cloud, they call it, to develop like the closest thing you're ever going to get to being there. And then you can couple that with, in this case, our packaging expert, who could explain that this illustrates his opinions of how this product would have moved based on the dimensions. And what you end up with is a massive amount of work that goes into a 1-minute presentation. And
Right.
I'll see if I can share that with y'all now. And this is what we call the wrong way animation. And I mean, this is accurate to the detail. I mean, the missing deck board on top here is accurate. The shape of the contours of the underside of this, the number of boards underneath, the channel in this metal rail, and the number, 13 by 7, I mean, the green banding location. And what you end up seeing, the first part was to show the dimensions of what this is. And as you can see on the bottom, I don't know if my cursor shows up, the plastic wrap doesn't extend all the way down onto the wood.
Oh, okay.
And so you'll see, here's the top view. We kind of show what's going on around this object just to give folks a sense of what was up there. And then we'll get rid of that so you can see the mechanism. And our client is the gentleman on the left in this aisle, the temp workers here on the right.
Oh my God.
And so you can see that something that is, it's difficult to watch even in animation, but it becomes clear what happened. And,
The
more
metal of that trolley right there is all crushed in. I mean, even that detail there, and
Yep.
that's incredible.
Yeah, the detail is incredible. And it really came in handy for us later because we had a real stickler of a judge when it came to like demonstratives and things of that nature. So we probably wouldn't have been able to use these at trial if they weren't as precise as they are.
Wow.
Yeah, I mean the standards. I mean, for folks who've tried to admit animations, they know generally there's a demonstrative standard and there's a simulation standard. And we weren't even trying to use this as substantive evidence. We wanted it as a demonstrative, and we essentially had to meet what was a simulation standard. That this was identical. Our animators were deposed. They were asked whether the output was what they had generated. I mean, these beams, I can tell you, I mean, we're to the quarter of an inch are accurate. The shirt this guy's wearing from a surveillance video that teal was pulled from, everything is as accurate as humanly possible. And, so once we were able to show this, we got a bunch of animations that we're not able to show today necessarily, but then this is the wrong way, right? And so what would have happened if it had been done the right way? And our expert guy out of Lansing, Michigan, named Dr. Paul Singh, we were able to put together, look, the issue is securement. So if you look at this object, there's a plastic wrap that goes down, and what's supposed to happen is the standard of care is it's supposed to go all the way down and around. And once you do that, you have a unit load. The problem in this case is you had a piece of what we called black ice, this black plastic underneath that you can remove and help yourself out and avoid some slip. But they left it, and then they didn't secure it. And then when you watch how this slides off, it just makes it very easy where the slightest angle that's created by this contact is less than 3 degrees. It comes down the whole thing. And it's 1,300 pounds. And if they had just taken the time, we're fond of saying, if you remember one thing, right, in your opening statement, in this case is about 5 minutes and $5. That's the amount of time it would have taken them and the cost it would have been to them to do this thing the right way, to send it safe. And then we had
highlight just 2 things that you guys have talked about. So for the audience, who is kind of, get maybe people who know the edge really, really well. Maybe other people are kind of getting into it. Maybe others have just stumbled across this. But 2 things that have really come clear to me throughout just the few minutes we've been hearing about this case are, number 1, woodpecker. Okay. Don't stop the obvious defendants in a case. I mean, what I'm hearing from Andrew and Alexa is that they went all the way. I mean, you heard it from Andrew, all the way to China. Don't stop at let's see, the temp agency or the store or the person who put, this pallet here in this location. Chase that rabbit hole, go all the way down, because you got to bring everybody to the party, right? You don't have the opportunity to do that later. And when you have a very seriously injured client, you don't want you want the sky to be the limit when it comes to the availability of resources to recover from the defendant. So that's one of them. The other is know what you have to prove and know it early, right? You don't want to get to trial and have a stickler of a judge who says you cannot use this animation that you've spent a lot of time and money on. So get in there. And I know it's a little bit of backtracking, Andrew and Alexa, but will you talk to us a little bit about how you made sure, either through discovery or through witnesses in depositions and that sort of thing, to make sure that you could get this animation in? Because I know that's something people struggle with. And I even had it was actually another stupid demonstrative that should have been allowed in, but it was excluded because judges just don't know the law, which is sad to say, but it's true.
Yeah, they're really not comfortable with them, and I have immense respect for this judge, and I don't, especially in a case of this magnitude, caution can be a good thing for both sides. But yeah, I mean, the standard essentially became one of having to admit a simulation, which is not just that this fairly and accurately represents what you say it does, but I mean, there was concern. I mean, we started the discussions on admitting these animations with the judge saying, well, I had someone try on my last trial and I rejected it. We said, good, we're off to a good start. Yeah. And so, I mean, the answer is early. Disclose as early as you can. I know that's hard with trial work, especially when you're talking about spending into an animation. But I mean, this case was tried in October of 2022. We started jury selection the month before, and we had a mediation in June. And we made sure, I had started working on these animations probably in February or March. And we had, as much as we had done, disclosed for the mediation itself. So we could say, look, this was out early. they've had this for 4 months, and they tried to nitpick at the animations, and we said, okay, judge, have them tell us what the issues are, so we want to get it right. So if they're going to say it's not accurate, the goal here is to get it accurate and have it be right. And so I'd like them to list what they think the issues are, and we'll get them fixed, and we'll accept or reject and let the court rule on the rest of it. So getting out ahead of it, we disclosed them preliminarily and as part of the mediation, and then we filed affirmatively a motion in limine to admit the animations. We made sure they had what they needed. There was an open question about what level of discovery was allowed. Because I don't think a lot of courts know whether or not they can depose the animator. Technically, I don't think they should have been allowed, because are they going to depose the Staples rep who prints your enlarged demonstrative too? But it's a little trickier when the court wants some certainty, or they're not so comfortable with how the animation's created. And I actually think to some extent, it helps educate the court about what the process is. So, and we looked at it as an opportunity to show the work we had done, because they wanted to depose our animator, and challenge the foundation. And we said, okay, well, great. Well, we want to play a little bit of that at trial, because they're going to hear all about how this guy worked for Steve Jobs and the work he did for him, and just the level of detail. And it became kind of interesting at trial, because they tried to cross-examine the animator on all of my involvement, right? This classic, like, this is all steered by Attorney Garza, it's all big conspiracy. And all they ended up doing, I think, is showing how detail obsessed I am. Because it'd be like, I'd send an email and be like, okay, there needs to be 3 wooden boards. This one's broken. The color is not quite right. And it really showed them the work we put in to get it right.
Mm-hmm.
Well, and I think the fun piece of it too, if I can jump in, Andrew,
Please.
is a lot of the foundation of those animations were actually the defense experts' work product. So it's hard for them to dispute, the accuracy of the animations when it's like, well, hey, these were your guys' like laser scans and photos, and they went to the warehouse and they did all this work. So you can't have it both ways. Did your expert do it right? Or, are you disputing that now, and these animations are wrong? So that was, that just sort of worked out for us in a way, but that was definitely a fun piece of it,
Yeah, it was also made more fun because we got all of his materials in discovery when we were going to depose him. And then I said, great, so we're going to turn all this laser data over to our animation company, and they'll be ahead of schedule because they don't have to go out and map the warehouse themselves. And then
they did the work for us. It was great.
We said, look, we don't question and then we ultimately were able to successfully preclude that expert's opinions, theirs. So it kind of felt like we kind of looted the body, and then we were like, we're done with you. But we said, look, we don't question his ability to use a ruler. We question his ability to opine in the way that he wants to here. But yeah, so we were able to, we turned, what they thought was a strength, and we handed that over to our folks, and we said, great, okay, we all agree on what this place looks like. You saved us a trip. Mm-hmm. We agree with your ruler, and now we'll put our experts' opinions on top of that, and then you've met some of your foundational requirements. But it was critical in this case to be able to show the jury what happened, how it happened, why our client is oblivious to what's happening, and why it couldn't have been avoided too. It happened so quickly that there's no world where it's avoidable. So I don't know if that helps, but the answer is early. And to your point too about being a woodpecker, this issue alone, I want to say there was probably 6-7 different briefs. We moved in limine to admit it. They moved to preclude it. They wanted discovery of our animator, and we fought over that. And ultimately it's just, we continued to try and to, and I told my partner, he said, you did a good job on these animations. I said, well, we got 5 of them. So if all 5 of them come in, I'll be happy. But, and they did. So we're very happy about that. But it's you got to be prepared to have the fight, disclose it early, so you avoid, claims that they're prejudiced. And it's really important to do it.
Disclose early, everyone. I know sometimes it's tempting to say, well, we have this animation, we want to kind of spring it on them at trial. We don't want them to know our theory of the case or whatever. I don't know how you guys feel about this, but I would say it's not worth the risk.
Definitely not.
Yeah. If you want to use it, get it out there. The facts are the facts, and you gotta be ready. There's just a practical limit to what judges are going to allow that late. Mm-hmm. And if they are going to order your expert redeposed because this is some undisclosed opinion, or so the defense says, or they want to depose the animator, you got to have time for that and time for the fights. And
Keep
yeah,
going.
no worries. So then this one's even shorter. This is a 3-second animation, but this is the right way. So I don't know if that's up on your end. It looks like,
Yep, I see it.
yep. And so here the plastic wrap goes all the way down and around like it's supposed to. It creates one unit load as opposed to two different things and an ability to slide. And what matters here is the center of gravity stays back. So you watch a 3-second clip and it just stays up instead of it. Because if the front edge even falls off, this is called a stringer pallet. If you ever want to know about pallets, I'm your guy, I guess.
We know all about them now.
I bet.
Stringer pallets, blockway, 2-way, 4-way. But yeah, so then it slips and it just catches before the center of gravity is over the front of the beam. It'll stop. It stays one unit load because it seems kind of improbable that a little bit of layer of what looks like saran wrap, but in effect is a lot stronger, can prevent a 1,300-pound object from falling. And it's all about acceleration. And, here, just that one clip, you have your expert explain it and he's an authority and you just show him, look, here's why, this is it. So regardless of what the temp did and who he was and what was going on, this could not have fallen if Phillips had done the right thing from the outset. And that becomes critically important because the temp had a pre-employment drug test the Friday before that was negative. A post-accident drug test on the Tuesday that was positive for cocaine. And it became a big issue in the case for a lot of reasons. One, it ended up being trickier than it appeared on its face because you get a positive result and you think, okay, this is all about the temp and that's all it's ever going to be about. And we ran focus groups and we understood that was going to be understandably a big area of focus. But then the Friday before we were going to open, our toxicologist was precluded. He's never been precluded. And the court
It's that stickler judge again.
Yeah.
And the reason, the reason was, there's an extraordinary amount of cocaine metabolite in his system, and cocaine's trickier than other drugs because the acute intoxication phase is so short. And, but there is, especially if someone's a chronic user or not, a very significant post-crash period where there's an impact on their psychomotor function. And our expert said, look, what we know is it was negative the Friday before, and what it was after this incident, immediately after, within 30 minutes. And we know that either he was acutely intoxicated at the time, or he was coming down from such an extraordinary recent use that it would have had an impact on his psychomotor function, his ability to see and to hear and to feel. And the judge said, well, there's just not enough empirical evidence, let alone the scientific evidence that we had, which was in the form of a reliable test. They didn't dispute the accuracy of the test. But they said, look, nobody observed any impact or any issue with him. And it's a little bit tricky because you wouldn't necessarily observe.
Yeah.
Yeah. But the judge,
cause it was this like an actual or approximate cause. Yeah. Mm-hmm.
And we knew because we had also, this is sort of also a little like inside tip, I think. But, we did retain a retired judge who is a very well-respected mediator to help consult on the back end too. And we fought summary judgment motions on this issue and we won. But we knew even though we'd won, this evidence is it's like plutonium. You need to make sure it's firmed up for any judge because once it's in, you can't unring the bell. And we knew that it was going to be tricky and a judge is going to really do their best to make sure it's reliable. And we think it was, and it should have come in. But ultimately too, like the expert they disclosed, we ended up after sort of having a minute of, well, how did that happen? Processing and realizing how big of a gift it was for us because at that point, the temp company and the temp, they had $6 million in coverage and they had made an effort to tender it.
Yeah, we never wanted them to be the primary target anyway. We wanted Phillips, that's the first in time. That's the deepest pocket. It's just this one temp worker that wasn't the main target. So like Andrew said, this did definitely end up being a gift.
Well, and the bottom line for us is we knew that regardless of what his condition was, and it's a big regardless when it's cocaine, if our expert says that had they simply attached this, it didn't matter who touched it, what their condition was, it can't come down. That was our focus. Right. And that made sense to us. And but we also knew from the focus groups we'd run that we ran in pretty much the same focus group 3 or 4 times where we would roll out the case very neutrally. We would show the animation so they just knew what happened. And then we were very careful about giving them some of this more electric evidence that we knew would sway them one way or another. And a lot of this was done, almost all of it was done on Zoom, where we would code a Google form and we would text them the link, or we put it in the chat and say, before you guys talk about this, I want you to vote in the form, and then we'll talk about it. And so you could get a sense in real time of how people were responding, what percentages they were assigning, to the extent they were, and why. And it becomes relevant because, then we knew there's some other stuff that happened that we'll get into in the case, but there were key pieces of evidence that we knew had the ability to affect what they thought or who they thought was responsible. And as soon as they hear about the drug issue, they're, it's 90% the temp and nobody else, or they don't want to hear about much else. But we also knew what the percentages would be if they didn't hear about that, because we rolled that out late. And so once it was precluded, we said, look, we knew that we could never settle out with the temp and temp company, because those are temp company and Phillips were always who they were looking for. And they always wanted to hear from that person. We weren't going to give them the gift of the empty chair. But the second that was out, we were like, well, look, if that's out, then Phillips can't talk about it either. And Phillips, in our opinion, is the target and should have been the target. And they simply done what their own law is. They said they had a policy and procedure where this was supposed to be done. It wasn't done. I think we proved that. They still disagree, but it wouldn't happen. And so that was one of the things where once we kind of talked it through, we said, look, I think we can settle out. I might get yelled at for saying that we settled out with the temp and temp company, because we don't.
I won't yell at you. I've done it too.
Yeah, no, and we were very, very, very cautious and it was very deliberate. We looked at, look, you could have agreements with folks, but then our state has rules on Mary Carter agreements where then they can try to impeach my client or bring up the fact of the settlement. And then this entire thing looks like it's some lawyer's game that the jury, and really we're like, look, this is too important. It's the rest of our client's life. And we're either everyone's in it together, or we're going to find a way to do this the right way. And so we ended up settling with the temp company and the owner of the racking system for $8 million prior to opening statements. And then the case became only about Phillips. And that was helpful for a lot of reasons. It's just a cleaner case. That simplify always was the goal. And their goal was to make it complex and, to kick sand and to blame everybody else and to make it about more than it is. And when the case ultimately got boiled down to one defendant and one or two rules, it allowed us to really streamline the presentation and make the point to the jury. And I was kind of alluding to some of the things that happened in the case. We actually have a second case that's pending against Phillips now that I can't talk too much about all of it. But the interesting thing that happened is we started to look backwards, and you talk about the importance of credibility in these cases and trying to lie and looking at defendants' conduct or misconduct, as the case may be. And we worked our way backward, and Phillips from the very beginning had shifting stories. The very first story, despite the OSHA photos from an hour after, was we're not even sure that that's our product in the photograph. And it was like, well, it has Phillips in big letters and it has a barcode and a SKU. But okay, I mean, when the director of logistics, we took a state court equivalent of a 30B6 from the outset. When the director of logistics for North America for the largest lighting manufacturer in the world tells you he's not sure that's theirs or that the product doesn't look quite right, you trust them, right? I mean, I don't know better than you. You've undertaken an investigation. You told me you did. And so we understandably left that deposition in 2019, and we sued everyone who touched that product from the time it left their loading dock in Pennsylvania all the way up until it was delivered to the warehouse in Hartford. And in the course of that investigation, there was no modification. There was no damage in transit. There was no issue. And so there was a puzzle of how does it look the way it does in Connecticut if that's not how you sent it? Right. And so their second story was, well, maybe if it is our product, it's not our packaging. And we said, okay, well, why isn't it your packaging? And really the main reason they said was because it had the green bands that you saw on it, the plastic. And I said, okay, well, why is that? They said, well, we didn't have anything ever that had green banding on it. That left that blue. Right. The blue band, yeah, yellow, clear, black, never green.
Yeah.
No green. Not now, not ever.
Not ever has it been green. Okay.
Don't even like green.
Green's terrible.
And then something interesting happened. So COVID delayed some of the discovery, but we got out to Pennsylvania and mountaintop area middle of nowhere. My expert drove down from Lansing, Michigan. I drove from Connecticut, and we got there in January. And the agreement was we had, I think, 60, 90 minutes, and we were allowed to look at certain things in the warehouse and the wrapping machines and what the condition were. And we were looking for anything that looked like what fell on our client, anything that had green at all, anywhere in the warehouse. And my expert and I walked in, and immediately sort of your spidey senses tingling. Like every upper rack in this allegedly very busy warehouse was empty. And that was intriguing to me because some of the theme that they had built in the case was, why did the Connecticut warehouse put this heavy thing up too high? It shouldn't have been up too high. And there's no rule that says it can't be, but that had common sense appeal to people. It looks big. It's 1,300 pounds. Why is it up there instead of on the ground? And so it kind of looked like this is their theory in physical form in the warehouse. And
yeah.
But we continued on with the inspection, and then they were very, what was supposed to be an hour, they were like, oh, you've been here 5 minutes, you've seen enough, you guys should move along. And then we said, well, we need to see the wrap machines. And they said, well, there was a fight about it. And we said, we just drove from Pennsylvania. If you have issues about the scope, we can deal with them later, but we're here. And we didn't notice at the time, but we took a lot of photographs. And when I got home the next day, I looked at my photos, and I printed it out like on 8.5 by 11 piece of paper, and I ran into my partner's office. I said, you're not going to believe this. And I had the OSHA photograph, and I had this photograph, and there was a single green band identical to the one on the product that fell on my client. And it was hanging out of a trash can in the area where they didn't want us to go. And that was the only one in any photograph of anything that was in sight in the warehouse.
Oh my gosh. That person, whoever was throwing away the green bands, is totally fired.
Number one rule of a cover-up is empty the trash can, I think.
Yeah.
It gets better though.
Oh my God.
I suppose I should say, for legal purposes, my opinion is
yeah, that's true.
that there was some evidence, some creative evidentiary issues in this case. And so we sat on it, and we said, well, what do we do with this? Because if I'm them, I'm going to say, okay, well, you came to my warehouse in 2021, and we didn't have green banding then, but we do have it now, and it's on these products. Not a great look because it just happens to be the same color as the one and the thing that hurt my client, but it's something. And so we decided to sit on it and to go through discovery. And we got their expert's discovery a couple months later on his investigation that he was allowed to go do that we weren't. And the photograph, he took a lot of photos, and nowhere in his photographs could we see anything with green banding. And then on a second look through, we zoomed in the very top corners, and there were way in the distance entire upper racks of green banded product.
The same racks that had been cleared basically for the inspection that we were allowed to do. So
because we couldn't see the whole warehouse. So then we were able to piece together, okay, well, that wrap machine is there and this is here. And then you could put them side by side, and the entire racks that were cleared that were in the area where that were exactly where these green banded products were in the distance in this guy's photographs when he went 2 months later. And so we said, okay, well, maybe now again, their theory, I mean, you have to see it. It's in your expert's photographs, right? They're going to say, they have new stuff. It's different. It's not the same. Nope. That expert testified in September, 6 months later, that he didn't see any green banded product during his entire inspection of that warehouse. He interviewed the employees, the number one and the number two. They told him there had never been any green banded product now, ever. And he didn't see any when he went, certainly did not. And that became intriguing because some of the photographs he took happened to be angled down just enough to cut out the upper racks where the banded product was. So we said, okay, great. Thanks for your testimony here. Anything you want to change? No, perfect. And then worked our way up. And I had a call with David Hoey. Actually, we were going to do the number two and number one on the same day. And I said, do we confront him? Do we save it for trial? And he was like, what do you have to lose? I mean, you have him on video. We record every deposition. And so, the number two says, not now, not ever, no green. Number one says, I've been here 17 years. There's no one in the world who knows this warehouse better than I do. I asked him, I said, like Truman says, the buck stops with you. He said, yep. And we had a little bit of fun at sometimes. And I said, okay, well, just to be clear, no green banding, not now, not then, not ever. And I asked him about 13 times, literally, so there's no confusion. And I said, okay, well, I want to show you a couple more things before we're done here. Anything you want to change? He said, no. And I pull up the photo, and we have this video recorded. And I said, well, could you tell the jury why there's a green band in the trash can the day we go? Zoom in on it.
So this is at trial.
This is not, no, it's in his depot. It's a video depot.
No, but I mean, when you say tell a jury, you're asking.
Oh,
him
I'm doing it. Yeah, I'm doing it because I'm going to play it at trial, and and so I'm like sort of staging it like the jury. So I said, can you tell the jury why this is in the trash can? And for the first time, he's quiet for about 10 seconds. He has no explanation. No explanation. Do you have any explanation for how or why that came to be in the trash can? None. Did anybody ask you to take those off a product and put them in the trash can before we got there that day? No, certainly not. But no explanation. No. And then, okay, well, let's show you the other one. There's an entire row, these upper racks of Green Bandit product, right? And he said, yup. And okay, so now you're changing your testimony that you have this. And it just became this moment where at that point we thought, well, we have a guy who's paralyzed, and we're hard on our clients in terms of helping them understand the limits of trial work and how jurors might perceive them. But the single best plaintiffs I've ever represented in my life, and we have what we think is them destroying evidence. Like they can't try this case. Oh, undeterred.
Okay.
Undeterred. This does not matter because, of course, the green bands played no structural role. So why is this even relevant at all? They say, and then they hire an expert to say, if first of all, we did it, we secured it, and clearly it was modified after it left our custody, though there's no evidence of that. But even if it had been attached, it would have fallen anyway. So we like to call this internally they did him a favor by not dropping the pallet on him too defense. And for a lot of reasons that defense had no legitimate basis in our opinion, and ultimately that expert was precluded after we got his data, which was fun. But
that's good.
So it just became this event where we said, I don't think they understand. I mean, this case is about credibility, and we're going to talk about this. We're going to talk about, and so we actually at that point tried to add some additional claims to the case, fraud, evidence destruction. And the court said, look, we're too close to trial because of all the other defendants that are involved and the length of time this is going to push it on. You can have those in a second case if you want, but they're not going to be a part of this case. So the jury verdict in this case was purely compensatory, and the jury was only allowed to hear about the one green band in the trash can on the day we went in January, and not about the other days and the upper racks and the rest of it. So they got it. I think they got it. I mean, the whole thing was it's not ours, and we said it is. And if it wasn't yours, why'd you go through all these efforts to say it's not yours and distance yourself from this product and blame everybody else and say it's something else? So
we had some fun with the green bands too, because we, like Andrew mentioned earlier, we ran probably 10 focus groups, prepping for trial. And so as Andrew mentioned, for a lot of them, we would sort of dole out the information like a little bit at a time. And when we shared that with focus groups, they get it immediately. They're like, this is a cover up. Like we had people being like, ooh, they lied, they got caught, like lied better, and so we had a collection of like all of these really great clips from our focus groups that we ended up putting together as part of our mediation presentation. And we're like, well, this will scare them. This will wake them up because, lawyers, like that's the whole purpose of focus groups, right? Like we have a tendency to not think like a regular person sometimes. So maybe they need to hear it from like real people who are seeing this. And, they watched our presentation and they were polite about it, but the focus group meant nothing to them. And we're like, well, they're lost kind of, they don't see the value here, right? That we do.
Yeah. And
we've
right.
done that in our focus group mediation presentations before. And I think we keep our focus group clips back and then see if maybe they'll be worth it. Otherwise, they flat out will say, well, you coached those people, or I don't know what you provided information to them, and it might be wrong or whatever. They're like, we don't trust your focus groups at all. So,
yep.
Okay.
Yeah, and we do think that the mediation presentation, it played a role in getting the other claims resolved, because even after the preclusion of our toxicologist, they made an offer to tender the money before. Even after preclusion, they tendered. And they knew we were serious about this case. I think anybody who was awake understood that this was serious. We were serious about trying the case. And, there were, I think at one point the judge said there's basically conflicting versions of reality. And I like to think that we were living in a world, because it was constant anxiety. I think as a plaintiff's lawyer, when you have anyone who you represent, you want to do right by them. And to your point about working all the way back to China, the one thing that we continued, like our mantra was, look, if he can live in a wheelchair, I can I can live with a little less sleep. I can do whatever I need to make sure that we have not, like, there's not going to be anything that's left uncovered, nothing that we're missing because we're going to be outworked at any point.
Mm-hmm.
And so, we ended up, Alexa, you can talk a little bit about the focus groups too, in terms of how we developed Loss to Consortium, because what we're particularly proud of too, the verdict we are for our client, and we're defending that now. And, but also the verdict for his wife, Emily, was $10 million. And that's the largest loss of consortium verdict in Connecticut history, on top of this being the largest physical injury verdict. So it was, and that was huge for us, because we felt like there were times during trial, I don't want to spoil it, but that they just didn't take her seriously and didn't value her like they should have. The defendants.
It can be tough too. When you have the partner or the sibling or the parent or whoever, that person's interested, and it's hard sometimes to know how a jury is going to, we've had cases where the wife was the best witness and we only had the wife, and we were so terrified. We're like, but that's the wife and she's going to benefit from this. And they loved her. But then we've had other cases where we've had great before and after witnesses, and they were, more disinterested, and the jury didn't like it. And so you just never know how that's going to go, but you kind of think, well, shoot, you have the wife and she's going to benefit, and how's that going to go? So tell us about how your focus groups helped you with that piece.
Yeah. And the difficult questions, right, Alexa?
Yeah. I think, to your point, Jenna, we never know like how a jury is going to react, right? Because they are interested. They have an interest in the outcome, obviously. So one of the things that we did was we had pre-recorded just some small snippets of our clients, like talking about what they had gone through. And we played those for the focus group and asked them to judge them, really. Like, what do you think of these people? And so that sort of gave us some insight into what regular people thought in terms of the credibility of our people. Because like Andrew said, I think these are the best plaintiffs we've ever represented, but we're biased, right? Like we learned to love these people and they became like family to us. So we're like a little jaded. We need an outsider's opinion on that. And we were getting nothing but positive feedback from our focus groups about how great these people were and how believable they were and how what they went through was so terrible and how no amount of money in the world could compensate them. But they also showed us a lot of, what we didn't know and why it's dangerous to make assumptions about what you think is going to be good or bad for your case without focus grouping it. Like a real issue for us was that the plaintiff, Mikey Cruz, had attempted suicide a couple of times after this incident occurred. And our crazy lawyer brains were like, we need to keep that out at all costs, because, if the jury hears that this guy is trying to kill himself, not to be harsh, but maybe they're not going to give him money, because what's the point? Like, what if he does it again? And, when you have his wife talking about it, and then, we're presenting that to a focus group, we found out like how wrong we were about that. And how that actually added a lot of value, I think, to both of their claims, because that was another element of the suffering that they had gone through. That was one thing. And then, we had a lot of hard topics that we just weren't sure how to talk about, or like how much detail to give, like the impact on their sex life, for example. So that was something that the focus group helped us out with tremendously too, because it's like, what's too much, what's not enough. We had great clients who were very open and willing to be vulnerable to a jury. So that obviously helped, but the last thing we wanted was like to be coming on too strong or to leave them with questions. So the focus group was incredibly helpful, filling in those gaps.
And to Alexa's point too, you had hard questions that, are they going to give him a full future medical care if they don't believe he's going to need it or live, right? Or but instead, the reply we got from focus, they're like, why didn't you tell us? Like, I might kill myself. I probably would. Like, it's like people think about this and it's human and it's normal and it's going through their head. And, you think you know it all, maybe as lawyers, but if you're smart, I think, you don't know much. But, those are things that we said, okay, well, we have to talk about these as hard as they're going to be, because part of the closing too was, a series of what if questions. What if the next attempt is successful? What if she leaves him home, leaves him with the wrong person to take care of him? What, the fears that she has as a spouse. What if the pain medication stops working for him? It changed the ways that we developed some of the expert testimony, where I talked to the pain management doctor who is his treater, and we talked about statistics and that people that are paralyzed, I can't remember the exact number, but I think it's at least they have suicide rates 10 times higher than those in the normal population. And so you have these themes that you're building into examinations that are important and are big elements of damages, and you reinforce them and you echo them through other testimony too. And, one of the things too that Alexa, we knew from focus groups, we had people come and they say, well, she's just going to leave him anway. He's in the wheelchair, but she's not, right? And it's hard.
That was a real fear of ours. Yeah.
And, that turned into a fear. We turned that from a fear into let's go at it. Right. So, her examination of the wife is, have you thought about leaving him? How many lawyers want to ask that question of a lost to consortium spouse? And we knew the answer. We knew who she was. We knew what their relationship was, and they saw her. And I don't think anyone believes, nor do I, that she's. Like anyone, she's had moments of difficulty, but she's never thought about leaving him. And those are the things that you have to address, the unexpressed questions that focus group and members of your jury are going to have, and you can't shy away from the hard stuff because you think you know.
And it's also really human too. Even if she had said, yeah, I've thought about it, but I'm not going to, it's almost a more real, true answer than, no, of course I never thought about it. Cause then you're like, well, lady, are you sure?
Yeah.
If you're just put on a show for us.
Yeah. Or one of her girlfriends who's a DNA witness who says that I've thought about her leaving him,
Yeah. Encouraging her to come on, you're young. You can,
That comes from a place of love. Your friends want the best for you. And it's not that they don't love your spouse too, but they, it's human to think and to talk and to live through these things.
Mm-hmm.
And we learned, and then it prompts conversations, with you and your client that maybe you wouldn't have otherwise had, because, we have to have this hard conversation so I can prep her for a testimony, right? And she says, yeah, I have these moments where I'm like, why did this happen to us? Why did this happen to me? But, the thought of leaving him never crossed my mind. But then we learned that in the emergency room or the hospital, when Mikey finds out he's paralyzed, he actually told her, in that moment, this is your out. If you want to leave me, I wouldn't make you sign up for this. You can go. And that was a really powerful thing that maybe we would have never known had we not been forced to have that difficult conversation.
Absolutely.
Yeah. And I think, it also showed us the importance. I think every case is different. A consortium case isn't right for every case, but we had focus group folks who were saying I don't think you guys spent enough time on her. They were defending her. And then that changed our whole approach in terms of at that point, from that point forward, Alexa was individually assigned to she had her own lawyer. Right. And because I had worked with Mikey over 5 years and both of them, but it was no, she needs her case built in her own right. And Alexa became her person, her, multiple interviews, witness prep, the examination, the relationship, the trust building. And it was important. It was important for her to be seen and heard. And it was almost, you can't script it, but then in the defense's closing, they didn't even talk about her, not even once. And that allowed us to get up and rebuttal, because there were pieces throughout the trial where in particular, they cross-examined our life care planner and they said, you've allocated some time for, some money for a CNA or home health care. And his wife was a CNA. And our position was she had never been off duty since September of 2017 because she worked and then she came home and she was his caretaker. And it still remains one of the rudest lines of cross-examination I've ever seen. You've allocated for this, but they're not paying for that now. And our expert, because he's not a blushing violet, was yeah, because his wife's doing it for free. Well, my question, sir, was they're not paying for it now. No, but it doesn't mean they don't need it. And that allowed us to get up in closing and say her life matters, her time matters, and we see her, and whether or not they want to value her time or they don't want to pay for it all, it doesn't matter. It's important to us. And then they don't even mention her in their closing, and we get up in rebuttal and we say, we don't agree with them. She's here. We see her. We know you see her, and we're asking you for a verdict in her own right, and it just, it was a long trial here. Selection took 3 weeks because we talked to jurors one at a time.
Oh my God. Oh my God. That's so insane.
Yeah, you have a constitutional right to individual voir dire here. So in state court, they come in one at a time, and I've said it's questioned by firing squad. It's about 45 minutes per prospective juror with the 3 defense lawyers and me, and to even get them to a point where you decide if you want them. So we sat 6 and 4 alternates, and it's a challenge. It's a huge challenge because when I go to voir dire and advanced voir dire, which I can't say enough good things about the KTI courses, the tricky part for me is when we get into discussions about the importance of crosstalk and bonding. You're like, good question. What if your jurors don't see each other until they show up for jury duty the day they've been sat?
Mm-hmm. What would you say is some unique things that you guys deal with in that respect? What do you look for in a juror to give you a signal that they will be a good cooperative person, or that they are strong in their opinions and won't be swayed if it's an opinion you like, or vice versa?
Yeah, so it's a great question. It's one we've struggled with as we've developed methods for Connecticut. And, really the answer is we ran focus groups to develop what we thought was the best juror profile. We looked at all of our data over all the focus groups to see, okay, who did we like, who was best for us? We had focus groups where we literally didn't even look at the biographical information. My paralegal would just put them on, and the 3 of us as lawyers would just present them with a case, and we would just listen to them and try to predict how we thought they would do or how they'd be as jurors, and then see how we did and how we matched up. And ultimately we had data to sort of generally decide who we liked demographically, what kinds of questions mattered. The methods from the EDGE advanced voir dire course in particular are evergreen, even for a state that's individual voir dire. And you do your best. I mean, you kind of know, you think like who is going to be a follower a little bit and who's going to be a stronger personality. And so we did our best to pick people within our profile that we thought would play well together. And I mean, by the end of it, I'm sure they still talk. I think they do. And, we were pretty certain about 1 of 2 people that would be the 4 people, and they were. And, and, I don't know that you can always predict that, but I think the goal for us is you can't encourage crosstalk and you can't encourage bonding. So there are times where we're like, okay, we have 5 strong folks. We just need a follower. Let's find somebody who's not a rat, who's a follower, and put them on. And so you're kind of gaming it holistically, and you're constantly like, well, how is that person going to play with that person? And do we need more women in the room because we've got 4 and they're going to feel overpowered? And, so that we're constantly doing our best to try to figure out how they're going to do together. But, I think we had an amazing jury. They saw our clients, and, we're forever grateful for them.
Were you going to say something, Alexa? I thought I was...
Yeah, I was just going to say, I mean, Andrew kind of hit on it, but it's almost like putting a puzzle together, right? Like we know we've got 4 pieces, and these are their personalities. So like when the 5th one comes up, what are we looking for that will sort of complement that? And it's tricky because you're not seeing them interact in real time together, but our process is like having a couple of people at jury selection so that people can take notes, and, we have an idea of who these people are, and, how they'll potentially fit together, which is some guesswork, obviously, but it's the best we can do, right?
Do you find that they are more forthcoming with you in their individual? I guess I don't know if you have anything to compare it to, but I mean, I almost feel like, I don't know, some people might keep their opinions to themselves if they think everybody else is going to judge them.
Yeah, I think that's my theory. I think the people that are introverted still have trouble sharing, and maybe have more difficulty sharing in a room with 4 people where someone isn't normalizing sharing whatever it is we need, particularly when they're very difficult issues. I mean, we came at consortium, hard, non-economic damages, hard, race as an issue in our case, and, difficult questions with people. And to some extent, I think they were more comfortable. Or it allowed you an out, or if you felt like someone wasn't a good fit because of the research we had done behind the scenes, and it seemed like they weren't comfortable, you could say, well, it really seems like you feel strongly that this would be a hard case for you to be on. So it can, sometimes you try to use it if you can. But I mean, we knew, from the advanced voir dire course, I don't think it's necessarily secret sauce, but if race is an issue in our case, our clients are from Puerto Rico. I mean, we ran a focus group where 50% of our participants in advance didn't know that someone born in Puerto Rico is a U.S. citizen from our jury pool. Yeah. We're like, well, there are attitudes towards people who are, whether they are or are not U.S. citizens or are or are not from Puerto Rico. People have feelings. Mm-hmm. And so we came at that very directly. You can't you can hope and be optimistic about the world, and that's a good life I think, perspective, but you have an obligation to, vet people and make sure they're going to treat your client fairly.
Right. I mean, it's not even just a citizenship thing on its face. It's this person is also coming into court and asking for a lot of money to compensate them. And so even if somebody might feel one way about just people from different countries in general, they might feel a different way about somebody who's coming in using our system. And if they don't have that quite a good understanding of what that really means for somebody who's from Puerto Rico, then that's a lot of layers. It's a lot.
Yeah. Well, you get the baggage of what people think about minorities in general. I mean, so at least Hispanics, and so you do your best to present your client as who he is. I mean, look, this guy has literally worked since he was 14 years old. I mean, he 3 jobs. He walks. We had to get the one client who was paralyzed who loved walking. I am not in shape, but this man walked to and from work and worked a full shift every day in the snow, walked his kids to school every day.
Wow.
And it's just, it doesn't, it's heartbreaking, but it's just, this is who this guy is and who he was. And I mean, I think we did the best we could to present the case, and the verdict is in large. I mean, it's a reflection of him and who he and his wife are, and the significance of what they've been through and will go through, really, more than anything that we did.
Absolutely. It was in person for you guys?
Yes.
Yep. Okay. Yeah, the case was tried over about 3 weeks, and the jury got the case. They deliberated for about a full day. They got the case early in the morning on that Wednesday, and then just before 5 o'clock, they came in. And
were you nervous? Did you think that was like not enough time? You're like, guys, we've been here for 3 weeks.
So, because lawyers,
scary.
Lawyers are neurotic, right? Which goes without saying. But within about an hour and a half, I want to say, I don't know, Alexa could remind me, there was a question. They only had one, but the question was, we want to know more about the life care plan. And so we were like, well, that feels like they're past liability pretty quickly. But then the insane part of your brain goes, maybe they're just counting the exhibits to make sure they have everything. And of course, until the verdict's in ink and you know what it is, I don't think it helps you to assume.
Yeah, to speculate. That's just,
Yeah.
But
they also asked for a chalkboard, which was funny. So we're like,
chalkboard?
What are they
like
doing in there?
Did you have an older jury?
They needed room to write the zeros, I think.
They're like, we're going to need another one, actually.
But yeah, it was pretty incredible to see. We actually took a conservative approach to the economic damages we asked for. We presented a very reasonable life care plan with median care. And we, said, look, you can go higher, you can go lower. And actually my ask, I think, was for 6.5 for the economics, but they ended up giving him 15. And which was within the evidence for them to do that. And then the non-economic award, I think in total, we had suggested 50 or 60. There was an approach that we used, which I have to give credit to Andrew Finkelstein we had a call with him the Saturday before closing, and I'd been through a number of drafts, but the way that we asked for the money and presented that to them and empowered them, we worked downward from a larger number. And we said, look, if you believe that 90 million is right in this case, we'd encourage you to fight for it. I think that's too high. And sort of we worked backwards from there, and they ended up, exceeding, my ask, which they can do. But it was, I'll tell you, it was surprising because they read the verdict form and we got through the specifications of negligence and the economic damages line. I knew what I asked for, and then the number was 15. And I said, well, wait a minute, like, is that a compromise? Because maybe they gave them more for the care and then somebody shaved something off of the non-economics. And then that number was not low.
Yeah.
And we just sort of stared in disbelief. I mean, our clients are 2 of the strongest people we've ever met, and they've been through so much over the last 5 years, and they have each other, and, we did our best to take care of them. And, but there's nothing quite like that moment where they could breathe and exhale in a true way for the first time in a very long time.
Yeah, absolutely. Absolutely. Guys, this is just so spectacular. Thank you so much for coming on here, really giving us so many things to work with as far as, woodpecking and being creative and using focus groups. I have to ask, because I think this is a question for any of us who have not gotten quite this kind of a spectacular verdict, but what's the status right now? I'm assuming you're on appeal. Is there been talks of resolution? probably can't talk too much about that, but what's the status? When will
so it's still an open question. So we argued, they filed post-verdict motions to set aside for remitted. We argued those in early January. Those are with the judge. They've got a couple months. We may get them sooner. But they've got a real hard choice here, because the verdict is entirely covered by insurance, which we didn't know until after verdict, though they were asked to disclose. They disclosed 20 million. They said, we found another 130, by the way. So we actually, and then we have the second case. So they have to think hard about, even if they were successful on appeal, which we think we had appellate counsel involved all the way. We don't think there are issues. Do you want to retry this with punitive counts? The interest on appeal is going to be $25,000 a day. How confident do you feel?
Mm-hmm. So if they did resolve it, let's just say hypothetically speaking, they're like, we'll just give you the verdict. Would you then not go for punies? Is that part of the resolution, or would you still go for it, but you'd only be trying it on them and not the whole thing with punies?
That's a good question. I mean, it's one that I'd leave to my client. We've done our best to keep ourselves and our ego out of this, as much as I would love to vindicate his rights again against what I think is pretty spectacularly terrible misconduct. He has less of a life to live than I think I will, and he deserves closure, and they deserve closure. And if that's what he wants, I'm on their team.
Absolutely. All right. Any final thoughts before we wrap up? I could go on and on, but I know our audience sets aside a nice little hour for us to do this, and they can always reach out to you guys afterwards.
Of course.
Absolutely.
Yeah, we're happy to talk. We're here. We love this community. This wouldn't have been possible without the support we've received during this case over the years. And we're just really grateful.
And as everybody heard, sorry, go ahead, Alexa.
No, I was just going to say thank you for having us and giving us this platform to speak on. It was awesome.
Yeah, no problem. Thank you very much for making the time for us. And folks, as you heard Andrew and Alexa both talk about reaching out to various people in the EDGE community. We don't just say that. We really are here for you if you have questions. And that's not, there are certain people who are faculty who are happy to reach out to you. Hoey was there for Andrew. People are here for you. And not only people who are, I guess, authority figures or whatever within EDGE, but other EDGE practitioners who have done this before and can tell you what worked for them and what might work for you. I know asking for a number at the end is incredibly difficult. So the fact that Andrew Finkelstein was able to assist on that and say, hey, this worked for me, why don't you try it out? And all that. All of these things are just really wonderful tools that we have as a community. So thank you, Andrew and Alexa, and thank you to all of you who joined us this week for Fridays with Keenan's Cutting Edge. If you liked the episode, please click the thumbs up to feed the YouTube algorithm. Let YouTube know that you find this content interesting. And don't forget to subscribe and sign up for alerts so you don't miss an episode. So next week, we are going to have a replay. We had a little switcheroo with the scheduling this week. This week is live, obviously. Here we are. Next week, we are going to have Elizabeth Larrick's witness prep episode again. And I encourage you, even if you've watched it once, check it out a second time. I know that it's on the YouTube channel. You can watch it whenever you want, but it's nice if you set aside an hour each week, which I know a lot of our audience members do. Check it out again. You'll probably pick up something different. Maybe you'll think of a reason to kind of reach out to Elizabeth and either use her in a case to assist with your witness prep or bounce some ideas off of her as well. So I encourage you to look at that. And then I will see you all on the next live episode when that happens. And I hope you have a wonderful weekend. I'll see you next time.